Can everybody hear me okay? My internet says that's unstable. Am I? Okay, good. Well, welcome everybody to 2021, to the first meeting of the Colorado Oil and Gas Conservation Commission. It is January 6th, it's 10 a.m. and we are all live, and we have a number of participants participating with us via Zoom. We will start with the roll call.
Yes, Mr. Chair. Commissioner Gibbs?
Here.
Commissioner Gonzalez?
Here.
Commissioner McGowan?
Here.
Commissioner Mesner?
Here.
Commissioner Nanjapa?
Here.
Commissioner Hackett?
Here.
Commissioner Robbins?
Here.
We have 7 out of 7 commissioners present, Mr. Chair.
Thank you, Hearings Manager Amaro. Appreciate that. Good to have everybody with us. Good to see everybody. We did have on our agenda as an initial topic, general public comment. We asked folks to sign up ahead of time for public comment, and no one signed up. So I think we must have exhausted the public in 2020 during our rulemakings, and at this point, so we will move from public comment. Next on our agenda is a report from the Department of Natural Resources Executive Director's Office. So that would be you, Commissioner Gibbs. Good to see you.
Hey, good to see you, Mr. Chairman, and good to see all the commissioners. And I wish you all a happy new year. It's hard to believe that it's already 2021, and it's been absolutely crazy and horrendous, I know, for many of us to deal with the pandemic and the challenges of some of us having to deal with kids at home while we're working, and just the landscape has just been challenging to say the least. But the Department of Natural Resources, I want to say, has been very resilient. I think we've really done very well this year. You know, for example, even during the pandemic, we've been able to keep all of our state parks open. You look at other surrounding states, they, shut down many state parks, but we, kept them open to have an opportunity for people to really get out there and hike and do things they can do safely. DNR also kicked off some really important advisory boards, the Colorado Geographic Advisory Naming Board. We've had a couple meetings of that so far. We've also kicked off our anti-speculation law work group on water policy to really shore up to make sure we have really strong water protection in Colorado. We had the worst, wildfire season on record, and the Department of Natural Resources was very much a supporting, entity to work with communities across the state on those challenges. And hats off to you all. We completed one of the more advanced oil and gas rulemaking in the country, right here with all of your amazing work, and with Mr. Trim, Jeff Robbins, and Director Murphy, and all the staff, and you as commissioners, your amazing leadership. Thank you, thank you, thank you. That's been just amazing. A few other updates for me. Some of you may know that yesterday, the DNR, we had our JBC, our Joint Budget Committee hearing, and just want to give you all a little snapshot of some of the areas that I covered in that. And you may or may not know, but this is a really important process in terms of getting the budget that we need for our department. This is part of the governor's proposal on what he submitted for his budget, and we have to go before the JBC, which is a bipartisan body that really helped to assemble the package of the budget before it goes to the whole General Assembly to be debated on and voted on. And I know some of you tuned into it. I think overall it went, quite well. And let me just give you a snapshot of some of the areas that I covered. I wanted to go over what our wildly important goals are for the Department of Natural Resources. So just to refresh everyone's memory, our first WIG, our wildly important goal for the DNR, is to focus on tracking and prioritizing water project needs in coordination with Colorado's 8 major river basins around the state. So the idea behind that is that we're working with local communities to figure out what their water needs are, and that's bubbling up to the state, and we're a supporting entity to try to get projects that are, the term maybe shovel ready would be. The next WIG is to balance outdoor recreation and conservation. That has Parks and Wildlife focus on developing a statewide vision, guidelines, and regional partnerships dedicated to achieving sustainable outdoor recreation and conservation of our natural resources and wildlife habitat. Part of that has also been a highlight that we were able to open up, Fisher's Peak, our first new state park in many years. So that's been really great to work on that. And then our third WIG is to work on sustainable funding for parks and wildlife. So that is an effort that directs Parks and Wildlife to look at examining new stable funding for wildlife, state parks, and outdoor recreation. And as a result of that, we are working on a legislative concept to really reimagine how we do funding for parks and wildlife. We're working with legislators right now on this concept. I'll share with you more as the concept gets kind of fleshed out more, but we're really excited to be working on that. And then this is our second year too of working on our equity, diversity, and inclusion goals that we have, part of all of the Department of Natural Resources. So this is has the Department of Natural Resources committed to incorporating EDI values into our culture, our core business practices, by implementing relevant best practices in hiring, employee retention, and community partnerships. Really proud to say that we have about 40 employees participating in our working groups that are taking a hard look at what accomplishments we've made so far, but also big picture, what we need to do and plan for in the future. Our budget requested included really three major areas. We wanted to, protect funding for our high priority programs, including funding for critical wildfire risk mitigation projects and conservation, and advance our WIG on balancing outdoor recreation and conservation. So our total fiscal year 22 operating budget comes to $316.8 million, of which $35.2 million is general fund. So we're an agency that's really limited general fund. Our first priority request from what was part of the governor's wildfire stimulus proposal, which makes a 2-year $20 million general fund investment for the forest restoration wildfire risk mitigation grant program, as well as our Water Conservation Board watershed restoration program. We saw last year, and we've talked a little bit about this, but we're one drought season, one lightning strike, one unattended campfire away from Colorado's next mega fire. And it's really critical that we take this time to invest in restoring our watersheds and protecting communities. And there's another side of that, stimulus package that's more on the fire suppression side, but the DNR is more on the mitigation side, the front end, doing defensible space around homes and providing grants to protect watersheds. And then on the back end, after we have, major fires, dealing with kind of watershed health. There is also a request that supports the expansion of access to our outdoor recreation opportunities. We have seen a huge increase in folks that are visiting our state parks, which is a really good thing. We have about 15 million visitors now a year. And so part of the economic stimulus package from the governor is also a request for a fiscal year 21, which we're currently in, supplemental capital request of $20 million to really jumpstart capacity expansion, infrastructure improvements. I know many of you enjoy our state parks, and folks that are listening too, how challenging it is to find a reservation to go camping and so forth. So we're looking at ways that we can expand our camping opportunities, expand parking, really look at this one-time infusion of funds that we could really improve the experience and frankly, safety and welfare of people that visit our state parks. And then also we had a specific request to to request staffing for our new state park for Fisher's Peak. That is a 19,200 acre piece of land, and we need staff to help. That we had a soft opening with the governor last October, and that is technically open, but we still have a lot of work to do to really expand what those possibilities will be for that particular park. And then also we had a funding request for FTE for habitat connectivity and transportation corridor. This is part of our effort to conserve Colorado's natural resources by enhancing big game winter range and migration corridors, and by also improving public safety. So big picture for this, the Secretary Bernhardt, Interior Secretary, had a secretarial order called 3362 that really encouraged states to take a hard look at wildlife corridors and see where wildlife are traveling and how that intersects with our roads, and really look at ways that we can mitigate, take safety measures to improve safety and also protect wildlife at the same time. So a perfect example of that is, how the state is exploring wildlife overpasses and underpasses, wildlife fencing. So this particular person will be a lead coordinator, working with the Department of Interior, the Bureau of Land Management, U.S. Forest Service, CDOT, Department of Natural Resources, to really look at where this intersects. In my home community, Summit County, for years we had just tremendous amount of challenges with North Highway 9 north of Silverthorne. Over a 20-year period, we had 600 accidents, 16 fatalities, 200 injuries as a result of wildlife issues. And they worked extremely hard to bring all the stakeholders together to bring wildlife overpass and underpasses. And believe it or not, that made a huge difference. And now we see an 88% decrease in accidents and a 90% decrease in animal fatality too. So good thing for people, good thing for animals at the end of the day. So with that, I'm happy to answer any questions. I mentioned we had the JBC hearing that was really focused on big picture, Department of Natural Resources, budget proposals. But next week we have a joint budget committee that's really focused on wildfire response and kind of what we're doing for the state. So I'll be participating in that. And then coming up soon, we have our DNR SMART Act hearings. Karen, you recall those, I'm sure. But that's something where you really present kind of what the Department of Natural Resources is all about, and talk about some of our priorities, our WIGs, and then any legislator can come forward to ask any questions. Last year, Jeff Robbins and I were in the hot seat for a bit. This year, I expect it'll be me, Jeff, and Julie, and whoever we bring us on the team to really kind of talk about operational and kind of what we're working on for OGCC, in the future. Jeff, we missed you yesterday. Julie and I survived, but it did go really quite well. And Julie, you did a great job. So with that, I'm happy to answer any questions. But overall, we had a heck of a year last year. We were so resilient, and I just really want to stress thank you so much for your amazing work that you're doing here. And I would say overall that we're doing for the Department of Natural Resources, but really looking forward to what 2021 brings. The vaccination is being rolled out. Let's pray for some more snow. Let's get us out of this drought. But happy to answer any questions if you have any.
Thank you, Commissioner Gibbs, Director Gibbs. Thank you for your leadership on all those areas. We certainly appreciate it, and we will do our best on our end here in 2021. And with that, that's a good segue to a report from Director Murphy, and maybe we can get an update on turning on new regulations and sort of next steps and how things are working. I know that some of us have listened in on some of the operator meetings, and it's been tremendous to hear from your staff on all the work they're doing. So I'm looking forward to your report as well.
Well, thank you, Chair. Thank you, Executive Director Gibbs. I'm afraid, Chair, you might be disappointed in my very high level discussion of where we are, except to say that we're working really hard to implement the rules. I think the best news for me is that the rules were published in the Secretary of State's Colorado Register on time, so they are good to go and will be effective on January 15th. So we're pushing all of our efforts to on the permitting side to getting forms ready, finalizing forms that are appropriate for approval before the 15th. And then, of course, our field and environmental teams continue to do the day in, day out work to make sure that oil and gas that has been developed in the field continues to operate in compliance. With that, again, we are also revising guidance documents, and we're conducting biweekly meetings with operators in particular to help them understand what it is we're working on, what the forms look like, what the guidance looks like, what our expectations are, so that operators can be planning alongside us. And so that when we get to new forms being turned on, people are prepared and can hit the ground running with us. In terms of, we presented the alternative location analysis component of the new rules yesterday to help, in my mind, kind of cement the ideas that what we're looking big picture for with alternative location analysis is for the land teams and the engineering teams within an operators to be thinking cohesively about what a good location looks like, both from the mineral side and from the surface. So I hope that was that to me was the big picture takeaway, and I hope that that message carried through. And as operators are thinking about planning for development moving forward, one of the big picture questions I get pretty frequently is what's left to be done for the Senate Bill 181 rulemakings. In my estimation, there are 3 topics: financial assurance, permit fees, and worker certifications. We'll be awaiting direction from you all about how and when to kick those off. I know that financial assurance is certainly in the forefront of many people's thinking, and we got questions about it yesterday during JBC. Thank you, Commissioner Gibbs, for giving an overview of that. It simplifies my comments today. And again, when we think about the day-to-day operations of our organization, we continue to operate as we have been operating since March, which is all of us remote. Our field teams have always been remote, but they are experiencing new and different pressures working remotely with mask mandates and with COVID precautions in place. And so we're continuing to work in the new normal as we continue to implement 19181. It's been a year of very dramatic change. And we will continue working from home through at least March 1st. And we're continuing to adapt and work through that. So one of the big operational pieces we had yesterday, and we have it annually, usually in January, is our one of our 2 all hands or all staff meetings. I think it went really well. I had to duck out a little bit early because of the JBC hearing, but one of the important things that we covered is that we were the first division within the Department of Natural Resources to receive the 1 DNR training. So thanks to DNR HR Director Wendy Padilla for giving that to us. And in that, she rolled out the Public Service Code of Ethics for DNR. And, we're really excited to make sure that COGCC's actions and words continue to align with what is expected of us through that Code of Ethics and through what it is to be a public servant. So it's a really dynamic time. We're in the last 10 days of getting forms together and rolling those out. We'll continue with biweekly meetings with operators for the month of January and into the future as it's appropriate, as it's helpful. We want to, make sure we have conversations that provide people paths to compliance, right? And make sure people understand what the expectations are from our side, and we'll be working through that. And we will be looking forward to, as quickly as is legally possible, bringing forward permitting decisions to this commission. After January 15th, I lose the ability to approve permits. And so we will be, again, elevating those decisions to you as quickly as we can legally and substance-wise. So we can look forward to that component in the near future as well. And with that, Chair, again, I kept it fairly high level with where we are on forums. If we want a more detailed dive, I can have, maybe we can do that next week when we're, on the verge of turning on rules, and either walk through what some of the forms are or walk through some of the guidance. I leave it to you all to help me understand what would be most helpful. So
Yeah,
With that-
thank you, Director Murphy, for
Yep.
that report. A couple of comments from me, and I'll see if any of the other commissioners have comments as well. But I think it would be good to have maybe on next week's agenda or the following, but just have on the agenda sort of a walkthrough of the development of the forms that your team has been working on. I think the commissioners would like to ensure that the forms that have been developed are consistent with where we were thinking we were planning on going. And we also just would like to be familiar ourselves with those forms. It's going to be a period of time before we get the permits that have been filed to commissioners, and getting us up to speed on that, I think, would be helpful. And doing that at a public meeting might also be helpful. It would allow our stakeholders to also sort of listen in. I know that the operators are certainly listening in and attending the operator meetings, and others can do that if they want, but that might be a good thing to have the walkthrough. And then the sort of the second piece, and I wanted to throw out this compliment. I listened in on the operator meeting yesterday, and I felt like that COGCC Senior OGLA, Sabrina Trask, did just an excellent job of walking through the alternative location analysis from commission staff's perspective. And I think that having a similar sort of walkthrough with commissioners, and so that the rest of our stakeholders could sort of hear that. Again, it's just an example, it's just a hypothetical, but I thought she did just a fabulous job of sort of taking rule language and putting it into, potential hypothetical real world scenario, similar to what Greg Duranolo did back in Sasquatch territory, but with a different, vernacular. And so having that again, I think would be great. And again, sort of thumbs up to Sabrina for great work. And I know all the OGLA team was probably behind that. I know they work as a team. And so I want to give a shout out to that team for the great work in the development of the forms, and in informing our regulated community about how to work through our processes that we've developed, in a comprehensive and protective manner. So good work there. I'm seeing other commissioners nodding heads up and down, so I bet they heard the same thing as well. Do other commissioners have thoughts, questions resulting from the director report? Okay, I'm not seeing any. So moving right along, I believe at this point we would have a presentation from Assistant Attorney General Kyle Davenport concerning Colorado Opens Meeting Law and ex parte communications. And for our 54 sort of stakeholders that are listening in, we're a new commission, and we're about to start to undertake permitting and the day-to-day business. The Senate Bill 19181 and the rules that we promulgated under Senate Bill 19181 establish that permitting moves from an administrative decision of the director to a decision of the 5-member commission at a public hearing. And that's a fairly significant change. And so we wanted our Assistant Attorney General to sort of talk through open meetings law and ex parte communications and what that means and how that works, because we want to be trained up correctly so that we are undertaking the business of oil and gas permitting review in an open manner and consistent with all of the open meetings laws, et cetera. So E.g. Davenport, I send the screen to you if you'd like to share and provide us some perspective.
Thank you, Mr. Chair. Good morning, commissioners. Hopefully you all can hear me. Please let me know if you're having any problems. Great. I'm going to share my screen. And is that working? Okay. Commissioners, good morning. I'm going to talk about two things today. As our chair said, open meetings law and ex parte communication. I'm going to apologize in advance for not looking directly at you throughout this presentation. I have notes on a different screen, and so hopefully that's not too disorienting. The genesis of this meeting is, as our chair discussed, the commission is moving into kind of a new world for this full-time commission, where it's going to be considering not primarily rulemaking, but a combined rulemaking and hearing application docket. and especially applications for OGDPs and caps, which is, as our chair also said, a significant change in the fact that the commission will now be hearing permit applications. The purpose of this presentation is to inform your discussion, which is on the agenda for after my presentation and after a potential executive session, to inform your discussion about best practices for communications. As the title slide notes, I'm going to be talking about one statute and one rule today. The statute is Colorado Open Meetings Law. That's 24.6, 401, and 402. And a commission rule on ex parte communications. After the mission change rulemaking, will be Commission Rule 530. It was previously Commission Rule 515. These are long-standing requirements and shouldn't come as a surprise to anyone who's familiar with the workings of government or who has appeared in a judicial or quasi-judicial proceeding. But I thought it was appropriate to revisit these things given the new world that the commission is heading into. The purpose of this statute and this rule is really to ensure that the commission's decision-making occurs in the open and that there is no unequal access or appearance of impropriety in the course of the commission's proceedings. I'll first discuss open meetings law and then turn to ex parte communication. Please don't hesitate to jump in with questions at any time, though I will note for you and for the public, depending on your questions, I may suggest that we go into executive session for some of them. I don't expect to do that for all of your questions, but it's a possibility that I will recommend we have that discussion in executive session. All right, next slide. So open meetings law, I'm going to start with the legislature's declaration of policy. This is the legislature's statement of why it adopted open meetings law. I don't have much to add to this slide itself other than to highlight the statement of policy. And that is, as I noted, it's the purpose of open meetings law is to ensure that all state agencies, and it applies to local governments as well, conduct their business in the open and not in secret. The next two slides are interrelated and essentially set the requirements for when a meeting must be an open meeting. An open meeting really just means two things. It means that the public may listen to what you say, what parties say, what whoever's participating in that meeting says. It does not mean that any person may participate. In other words, the commission is not required to have a public comment session or to allow anyone who is interested in speaking to speak at a meeting. That's your decision on when you allow participation and how you allow participation. The second thing that an open meeting means is that notice is given to the public of the meeting. So when we talk about open meetings requirements, what we're talking about is making that meeting open so that the public in the current world can listen to it through Zoom in hopefully what is a somewhat near future when we can return to normal, that we'll have, if we're meeting in person, that we'll have an open meeting room that public can come and listen to in person, and that the public has notice of that meeting occurring. Open meetings law, the statute itself begins by defining what constitutes a meeting. And that is, it's a broad definition. It's any discussion of public business. We will get to what constitutes public business in a minute. What I want to point out on this slide is two important things. First of all, that it's really any communication between commissioners. So that can be in person, on the telephone, via Zoom or Google Meet, texting, phone calls, any type of communication. And that it applies, a meeting is two or more commissioners. This is the same requirement for any state public body, any board or commission. For those of you who are more familiar with local government requirements, the state public bodies requirement is a little more stringent in the sense that it's limited, it is 2 or more members. For local governments, it's 3 or more members. So there is a difference there. The next thing that open meetings law statute does is define when open meetings law applies. That is, in any meeting, so a discussion between two or more commissioners, where public business will be discussed or where any official action will be taken. The official action is something that I think we could all easily identify when the commission is contemplating taking an official action, passing a rule, issuing an order, that kind of thing. If that meeting meets that definition, then it must be open and full and timely notice is required. The statute does not define exactly what constitutes how far in advance the notice has to be issued to be timely notice. It does define it for local governments and states that it is 24 hours. We have always interpreted that to be the same thing. If it's timely for local governments, it's timely for this agency. And so therefore, we have always endeavored to do certainly notice more advance than 24 hours, but that is the minimum requirement. So taking all of this together, if two or more commissioners are discussing public business or meeting to take formal action, the public must be able to listen to that meeting and it must be noticed. Again, I'll note the commission is not required to allow the public to participate in any meeting. It has the discretion, you have the discretion to set who participates and the course of your meetings. I'll turn to, I think, what is the most complex issue in open meetings law, and that is what constitutes public business. The open meetings law statute does not define public business. It is somewhat defined by case law in Colorado. Colorado courts have had occasion to issue opinions on whether or not an agency has violated open meetings law, and usually that has revolved around, was the agency discussing public business? This is a quote from one of those cases, and it asks the question of whether or not there's a link between the meeting and the policy-making powers of the agency. That is some guidance. It's not a lot of guidance. And these are issues that I think we will have to continue to work through, in the sense that we may need to have additional discussions about what constitutes public business. These are broad guidelines. Certainly, discussion of a pending rule or other formal action like issuing a notice or deciding on an OGDP or cap is public business. And the overall purpose of this requirement is to prevent the commission or any other public body approving decisions that were effectively made in private. In other words, the state legislature's policy is that it doesn't want an agency to talk amongst itself and then come into an open meeting just to announce a decision it had made in private. Public business or policy making constitutes, it can be broad, but it doesn't include anything that's of public importance. Certainly policy making, rule making, issuing orders must be in the open. But case law has determined that merely discussing matters of public importance is not subject to open meetings law. Commissioners, you can go to government conferences, you can discuss public events outside of COGCC jurisdiction without having to notice that for a public meeting. Social gatherings are also not subject to open meetings law. This is a quote from the statute. This is narrowly construed, but generally it means that if the purpose of you meeting is not to discuss public business, you can meet socially, you can go to lunch together, you can go to dinner together. This agency can have parties, holiday parties, and those are not subject to open meetings law. Finally, I will note that open meetings law allows for some non-public meetings. Those are called executive sessions. The statute sets the purposes that are allowed for those non-public meetings. Generally, this agency has had non-public meetings, executive sessions, to receive legal advice from me and your other attorneys at the Colorado Attorney General's office. Other matters may be discussed in private as well. Those include matters that are confidential under state or federal law, as well as personnel issues. I'm happy to answer questions now on open meetings law if you have any. Otherwise, I can turn to the ex parte discussion.
Why don't we do questions around this topic first, and then we could then move to the second topic. Move Kyle's screen over, and I see Commissioner McGowan raised her hand.
Thank you, Mr. Chair. So Kyle, you and I talked about this a little bit. I think what I'm struggling with a little bit in my head is the ability for commissioners to participate together in certain meetings and what it might mean as far as posting for the public. One example might be, I know that we're all interested in participating in the operators training, because for me personally, it helps to understand what questions operators are asking, what the forums look like. I'm not participating, I'm just listening. I think that might bleed into maybe a discussion of what that means for our ability to participate if more than one commissioner wants to call into, if a local government's having a meeting, and what that looks like, our ability to maybe participate as a listener versus a participant. And I'm wondering if you could clarify that a little bit so that we can all have an understanding of what that looks like. I know that, you know, during deliberations, we talked a lot about the commission, as commissioners, we want to participate as much as we can, and with community, with our local government partners, with community organizations. And so I was just wondering if we could clarify some of that a little bit.
Sure, I'm happy to, Commissioner McGowan. Mr. Chair, do you have anything to add before I go
No,
into
I was
that?
just going to recognize you, so please move forward.
Thank you. Well, I'm going to start with what I think is the broader question that you asked, and that is in regard to, for example, a meeting that a local public government may call. Meetings that governmental entities other than this agency call, any number of the commissioners can attend to listen in without this agency having to notice it as a meeting themselves or issue any type of indication that commissioner may attend that. Those aren't our meetings. We don't have to worry about ensuring that another agency complies with open meetings law. And as they are public meetings, and you commissioners are still members of the public when you attend a meeting, you may attend them. My advice in a very general sense would be, if you have an intent to participate in those meetings, I would encourage you to talk to me or another attorney that represents this agency to talk about how you would like to participate in those meetings. And there are a variety of reasons for that. I'm going to stop here. If we want to discuss those reasons, I think we should do it in an executive session, but that's my overall answer to the broader question. In regard to your specific example, I'm going to start my answer by reading directly from the statute. This is the provision of open meetings law that discusses what is an open meeting. It states that, and this is the quote, "All meetings of 2 or more members of any state public body at which any public business is discussed are declared to be public meetings open to the public at all times." So in my view, whether or not the commissioners are participating in that discussion is not the relevant inquiry. If 2 or more commissioners are there and a public business that falls within the policy-making powers of this agency is being discussed, in my view, open meetings law states that must be an open meeting. And again, that means it's open for the public to listen into it or listen to it, and that it is noticed. But it doesn't require a change to the course of that meeting. In other words, it doesn't require this agency to provide for a public comment period, et cetera, in the course of that meeting. I recognize that this is a significant change to this commission's practices, in the sense that you are now full-time commissioners. It's your job. You have much more time to attend these meetings that the volunteer commissioners did not necessarily have. And so that's a change to things. And I think depending on how far we get today, that may be something you want to discuss as to how to figure out how to meet that requirement for meetings that in the past, the volunteer commissioners may not normally attend.
And Kyle, just to sort of segue off of that, the commissioners as full-time commissioners, you know, we've had discussions and we're still in the process of figuring things out, but, you know, we want to use our capacity to sort of actively engage on matters of importance to commission. You know, just as an example, you know, Commissioner Gonzalez may be running lead on sort of efforts to educate us around pooling and otherwise. And so that would involve meetings that he may run, right? And then, you know, I may want to listen in because, you know, that's an important topic. And, you know, similarly, Commissioner Nanjapa may do some things, you know, around her areas of expertise around, you know, wildlife. And, you know, there's some of the things that came out of the rulemaking in which we wanted to have some work groups. And I would anticipate that, you know, Commissioner Nanjapa may be running lead on that and organizing. And again, it's this commission using our capacity so that we're all working toward common goals. And that's important information. And I would anticipate that some of the rest of us may want to, you know, listen in. And, you know, I don't want to get down to the details or on open meetings for every single thing, but can you give us some guidance around those couple of illustrative examples about how you would want us to notice or not notice or be involved or not be involved on those lines? And commissioners, I hope you're okay with kind of peeking into the details of some of the things that we've talked about doing. And you know, I think it's important for everybody to kind of hear this.
Thank you, Mr. Chair. I'm happy to. I'll start my answer by saying, I think it's important that we also have discussions specifically about a meeting, and if that needs to occur in either an executive session or one-on-one, that we can do that as well. In a general sense, first of all, an individual commissioner may have a meeting with whoever they want. That's subject to our ex parte discussion that we'll have in a few minutes. But an individual commissioner may meet a person without needing to comply with open meetings law. It is when a second commissioner wants to attend, a second or third or fourth commissioner wants to attend that meeting, even if it's just to listen in, that, as I said, in my view, in my answer to Commissioner McGowan's question, open meetings law would require two things. One, that meeting be open for the public to at least listen to. And second, that it be noticed at least 24 hours in advance. That notice can be posted in the way that the notices of the commission's meetings, the current meetings that we've been having, have been posted. In my view, that's not an onerous requirement. It's something we do all the time, posting meeting notices. We can continue to do it. But that would allow commissioners, as many commissioners who wanted to attend that meeting if we've met those requirements. It would also allow the commissioners to participate in that meeting, to ask questions, to express views if they thought it was appropriate. And if we had already noticed, and if that meeting was open to the public, commissioners wouldn't have to worry about, oh gosh, am I able to ask a question right now? Or can I say something about this right now? So my guidance is, if two or more commissioners wish to attend a meeting that is about public business, that meeting should be an open meeting and it should be noticed on the commission's website. That may mean we will need to have individual discussions about, there may be times that it may be appropriate to have a discussion between an individual commissioner or between staff and any particular person that you may just prefer to start that conversation in a way that's not in an open meeting, and that's okay. The open meetings law doesn't prohibit that. It would just need to be a single commissioner or just staff and whoever that stakeholder is and the director having that meeting. That also means that you'll need to do some calendar coordination. I think the good part about this is if you made a practice of noticing things, commissioners wouldn't need to worry about, can I attend this meeting or not? And can I participate in this meeting or not?
Okay. That's helpful. Thank you. Commissioner Messner?
Thank you, Mr. Chair. So that's all helpful and good information. I did want to go back, and this, I know that this has to do both with open meetings law as well as ex parte. So if we want to kind of get into this later, that's fine. But I do think that through the rulemaking process, we've indicated pretty clearly that we want to engage in any local government process that the local government is interested in having us engage in. And understanding the challenges around open meeting laws and ex parte in order to be able to do this in a functional way. I mean, I'm envisioning having to work with local governments to develop a joint hearing process for some of these reviews so that we are able to, you know, have a joint public hearing for both their local process as well as for our process, and that information that is gleaned from that meeting could be on the record in both the local government process as well as our process. And so I would be curious to discuss that. I just don't know when you would like to discuss that, perhaps at the end of the ex parte conversation as well.
Thank you, Mr. Chair. Commissioner Messner, I think I'm happy to discuss it a little bit now. We may want to defer some of it to after the ex parte. And the commissioners themselves, you may want to discuss some of this in your discussion. I think the chair has used the analogy of building a ship while we're sailing it at times through the rulemaking. I think this falls within that category of things. Obviously, the commission has made it very clear that if a local government wants to have a kind of a joint permitting process or wants to work in concert with the commission through the permitting process, that is an important goal for this agency to be able to make that happen. And open meetings law, I don't think, and ex parte communications, I don't think will prohibit that from happening. There are just a few constraints that we may have to pay attention to as we go forward. Certainly, if this commission wants to hold some type of joint open session with a local government in regard to a permitting, an OGDP or a cap, for example, open meetings law doesn't prohibit that because we're contemplating an open meeting. It's just a joint open meeting. Where we would get into more of a concern about the open meetings law concern is if two or more commissioners wanted to have a conversation with a local government about a pending permit application. There, I'd want to have a more detailed discussion about that specific instance and what exactly the goals are and what exactly the conversation that you commissioners may want to have is.
Thank you, Mr. Davenport.
Thank you.
Other questions from commissioners at this time? Okay, maybe we want to move to the ex parte contacts part of the discussion.
Thank you, Mr. Chair. I'm going to preface my ex parte communication discussion with a little bit of a discussion of your role. As you are very familiar with now, the commission acts in a quasi-legislative manner. That's what you've been doing for the past 6 or so months in your rulemaking. This commission also acts in a quasi-adjudicatory or legislative way when you hear, or excuse me, adjudicatory or judicial way, thank you, when you hear applications, when you hear enforcement matters. The quasi means you're not actually the legislature, you aren't actually judges, that's what quasi means, but you are acting in a legislative or judicial capacity. And you're acting in a legislative capacity when you conduct rulemakings, you're acting in a judicial capacity when you hear applications, in that you will determine facts, you may decide legal arguments, you will determine the rights and obligations of the parties before you. That's a judicial capacity action. As you are not actually judges, the code of judicial conduct does not apply to you but as you are acting in a judicial, quasi-judicial capacity, the commission has appropriately applied some of the constraints on judges in the decision making. And one of those constraints is the prohibition on ex parte communications. I'm going to be speaking about Commission Rule 530. It was previously Commission Rule 515. As I stated previously, this is not a new requirement for the commission. The only real change the commission made in the mission change rulemaking was to move the rule itself. It was not substantively changed as part of the 181 rulemakings. My first slide that's on the screen right now is a definition of what an ex parte communication is. And it notes also that this applies to hearing officers of the COGCC as well. The ex parte communication applies to an ex parte communication is communication between a decision maker and a party or any other person about the issues in a case without the other parties to that case's knowledge. It's intended, the prohibition is intended to avoid the creation of an appearance of bias or any type of special access to that decision maker. Commission Rule 530, 515 right now, 530 on January 15th, prohibits ex parte communications between a commissioner or hearing officer and any person about the merits of a proceeding after an application has been filed. I'll note a couple of things about that. First of all, it's any person, not just parties. It is also, the demarcation line is after an application has been filed. That's when the ex parte prohibition kicks in. If prohibited communications are attempted, or if a commissioner or a hearing officer actually has an ex parte communication, our rule provides that it must be made part of the record. We have had that happen in the past. In that case, it was an attempted communication with a hearing officer. The hearing officer immediately contacted the other party to that particular matter, notified them of the communication that was attempted, sent the communication to them, and set the matter for a hearing the next day to discuss the consequences of that prohibited attempted communication. There are potential negative consequences for a person who attempted the communication. Rule 530A4 provides that the person who attempts such communication is risking having their application or petition dismissed or denied as a result of attempting an ex parte communication. This prohibition also applies when staff is a party. We'd be talking about the enforcement context there. So staff is a party to proceedings before the commission in enforcement, and a commissioner communication with staff in those matters would be a prohibited ex parte communication. The last thing I want to point out in regard to ex parte communications is rulemaking is different. Rule 515B now, 530B later, provides that communications that would normally be prohibited in an adjudicatory setting are allowed in a rulemaking setting. They should generally be made part of the record if a substantive communication is had. And that communication should stop when the record is closed. The record may be reopened, but when the commission closed the record in a rulemaking, that previously allowed communication must stop. That concludes my comments on ex parte communications.
Thank you, A.E.g. Davenport. Questions from commissioners? Commissioner Messner.
Thank you, Mr. Chair. So I understand the ex parte piece when it applies when an application has been submitted, but my understanding as well is that it can be applied to an application that is contemplated to be submitted at some point in the future. Is that right?
In my view, Commissioner, thank you, Mr. Commissioner, Commissioner Messner. In my view, that would be, I think, a good decision that would be in the interest of preserving transparency, et cetera, for the commission. That is a policy decision that you commissioners would make. The rule itself does not prohibit pre-application communications. I think what you're talking about maybe is a hypothetical where someone calls up and says, I'm thinking about filing this application. What do you think of it? And what does the commission want to do with that type of communication? I think that's certainly something you can discuss in your discussion after my presentation. I will note that the Code of Judicial Conduct, which again does not apply to you, but our rule 515, 530 was somewhat based on that Code of Judicial Conduct. It doesn't apply to you. It does prohibit communications for what it calls impending matters. In other words, it would prohibit someone calling a judge up and saying, I'm about to file this complaint. What would you dismiss it if you got a motion to dismiss? It would not allow that type of communication, even if the complaint had yet to be filed.
Again, that's not strictly applicable to us.
That is not.
Because we're quasi, we're not actual judges.
That's absolutely correct, Mr. Chair. That is a Code of Judicial Conduct provision. It is not in your Rule 515 now, 530 in a few days.
Okay. Other questions from commissioners around the ex parte presentation? And Kyle, you may have mentioned this at E.g. Davenport, but you know, oftentimes, and I've seen this in the county commissioner context when I was a county attorney for a long time, county commissioners would have a discussion with a citizen not knowing that it ended up being a discussion about something that was pending, that already had been applied for. And, you know, I know the answer to this, but can you inform our stakeholders, you know, first off, don't do it. You know, if you've got an application that's pending before the commission, you ought to be apprised of the fact that that's not a good idea to go talk with one of the commissioners about that application, because it may remove that commissioner from being able to be a quasi judge on that application. But from the commissioner's perspective, if we, like in the discussion or later on, learn that that discussion was about something that was pending, what do we do?
Thank you, Mr. Chair. In a hypothetical situation like that, and I'd want to certainly discuss the specifics with any of you who are concerned about that, and we do that in an individual conversation probably to start with. In a hypothetical situation like that, my advice would be to disclose that communication, certainly, and certainly as part of your disclosure, say I was unaware at the time that we were having a discussion about a pending matter. I think that raises something that I would certainly advise you is if you receive a phone call to clarify at the beginning of the conversation what that phone call is about. And if it raises something that raises in your mind a question of, are we talking about an application that's been filed? It may be good to tell the person who called you, hold on, I need to call you back. I got to make sure I can have this conversation with you.
Okay. One other question that I have, and I'm asking this question just because, you know, we are a commission of 5 voting commissioners, but we do have 2 ex officio non-voting commissioners, the you know, EDO DNR Director Gibbs or his designee, and CDPHE Director or her designee. And I think I know the answer to this, but all these rules apply equally to the ex officio members, even though they're potentially not voting members. Is that accurate?
That's accurate, Mr. Chair, that the open meetings law or ex parte rule does not make a distinction between voting and non-voting members of a board. I will note, however, that Commissioner Gibbs, Commissioner Putnam, Commissioner Hackett, Commissioner Boag all wear different hats and may switch hats as part of their conversations at times. And that, whether they're having that conversation in the capacity, in the case of Commissioner Putnam, for example, in his capacity as an employee of CDPHE, does make a difference.
And I would encourage you to have those discussions offline with those commissioners. You know, I see Commissioner Gibbs is with us, and he obviously has a nice big CPW hat that he can wear, and he may need to have discussions with operators about something that involves wildlife that, you know, may also have something that involves with us. And I just want to, I guess part of the reason we're having this discussion is we want to create a record that we want to be open and transparent and consistent with all the laws of Colorado, and we want our stakeholders to all be aware of that as well. So this is educational for us, and this is educational for our stakeholders, and we will have this and people can go back and look at it and sort of see that. But I think that, and I know you've been doing a great job of reaching out individually to commissioners, and so I commend you for that. And again, as we get back to the building a ship and sailing it, you know, we may need to, you know, revisit these ideas, you know, as our ship gets more fully developed. Commissioner Messner.
Thank you, Mr. Chair. And I just had a couple other questions just to clarify. The ex parte piece in a public meeting is, so as far as applications in process, I mean, there is mechanisms for folks to communicate with the commission through the formal process, right? And so I think it's important for the public to understand that it is possible to communicate with us through letters or public comments or different things through the hearing process, so that it's not just that we can't hear from them. And then two, you know, if we do get an email, you know, about a particular application as an individual commissioner, as a group of commissioners, how to handle that, I guess. You know, I'm assuming that should not be read, but it's hard to know what's in the email until you open the email, kind of deal. So thoughts on that, I guess.
E.g.
Sure.
Government.
Thank you, Mr. Chair. Thank you, Commissioner Messner. First of all, I totally agree. This commission has created a variety of different ways for the public to engage, even on pending applications, in a way that would not violate ex parte or open meetings law. Certainly, this commission has general public comment sessions where a member of the public could come and give a comment on a pending application, and that public comment would not violate ex parte communication because it is in the open. It would not violate open meetings law because it is in an open meeting during a general public comment session. You as commissioners would not have to say, whoa, 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 stop talking. That person could make that public comment. How you respond to it is something that we may want to discuss in more detail, in greater detail later. But in regard to your second question on an email, I think that's a good thing for the commission to discuss as a matter of policy, how it wants to deal with potentially a random email that may come into your inbox that is about a pending application. One option is to just inform that person that you're going to treat that as a public comment, that you're not going to respond to it, but you're going to treat it as a written public comment. It will go into the record for the commission's hearing on that particular application. There are other ways, I think, that you could deal with it that would not violate ex parte communication or open meetings law. That's just one option. And again, I think one of the subjects of your conversation after my presentation could be about how to handle that as a matter of policy.
Thank you, A.G. Davenport. Other commissioners with questions, comments, thoughts? Okay, so I'm seeing none. Again, thank you, A.G. Davenport, for today's presentation, as well as your individual meetings with each of us as you coach us up on how to be quasi and non-quasi and doing all this stuff in an appropriate capacity. It's interesting, this birthing of professional commission. You know, we jumped into the deep end with the rulemaking back in July, and you know, now we're, you know, swimming out into the, you know, the second pool where we're going to get into the daily permitting. And you know, I appreciate the fact that all of us are diligent and trying to understand the swimming lanes, and to continue the metaphor. And we look forward to continuing these discussions as we move forward. And I would encourage commissioners that, and I know you all do this, but Kyle is easily reachable if you have questions, and it's better safe than sorry. So we can always reach out to Kyle individually if specific instances show up that cause us to wonder. So great. With that, our agenda calls for lunch break and executive session, but I want to go off agenda just real quick. We had in our chat box 2 individuals that indicated that one individual potentially had signed up for public comment. We did not receive any official sign up for public comment, but I'm happy to take an individual's public comment, even if it's not at the originally agendaed time, because we don't have a lot of people that have expressed interest at this point, which is fine. So with the commissioner's indulgence, I would suggest that if there's someone that is with us via Zoom who desires to provide public comment, raise your hand, or otherwise chat it up again, and we'll find you and recognize you and listen to you. Mr. Forks Goodmanson and or Miss Susan Noble, were either of you that person, or do you know whom that person is? Okay, Miss Noble, it appears that Mr. Forks Goodmanson believed that you signed up. If you're with us, I'm going to ask Hearings Manager Amaro to try to find you and to bring you to the fore. Look at that magic. Ms. Noble, you perhaps can unmute yourself, and now you have. And if you'd like to present a public comment, please, you are recognized.
Thank you very much, Commissioners. I truly appreciate this opportunity. I'm sorry that my request for public comment somehow got lost in the process. It was probably user error, so again, my apologies. My name is Susan Noble. As a concerned Colorado citizen, I've spoken before the COGCC many times to express alarm about health and safety dangers of oil and gas activity and about the oil and gas incursion into populated residential areas. At that time, I was one of the leaders of North Range Concerned Citizens, which I co-founded. It turned out I was not alone in my concerns, and I was elected to the Commerce City City Council in 2019. Today, I come before you again as a concerned citizen and not to represent my city council. In January of 2019, a band of neighbors from Reunion, Buffalo Mesa, Buffalo Run, Turnberry, and Potomac Farms in North Commerce City came together to protest several drilling and spacing unit applications submitted by Extraction Oil and Gas. Despite the innumerable hoops that existed then, they were successful in forestalling approval. Today, I want to draw your attention to this issue. On your consent calendar is an extraction, drilling, and spacing unit application that was bifurcated by the hearing officer during the protest I just referenced. There are 2 sections in this DSU application that have no relationship to each other than they are both extraction and both are cited in Commerce City, but they are miles apart. One would hydrofac under Bar Lake, it's DSU number 6. The other, DSU 8, the Pelican site, hydrofracks under Reunion South, which is a densely populated area. Because the mineral rights were owned by the developer, the residents in Reunion South and new home buyers are unaware at the time of the formal protest last year. I want you to know what you would be approving today. This is part of an unrelenting effort by Extraction Oil and Gas to site megapads in North Commerce City that would frack under tens of thousands of homes in a town already besieged by toxic industries and geologic instability. Many of these extraction oil and gas sites are in the ward that I was elected to represent. We are appreciative of the new rules that you have put in place or will effectively go into place on January 15th, and look forward to your continued leadership on behalf of the health, safety, and welfare of Colorado in 2021. Be well, be safe. Thank you for your time, and congratulations on your new positions.
Thank you, Ms. Noble. Do commissioners have any questions for Ms. Noble? Commissioner Messner.
Thank you, Mr. Chair. Thank you, Councilor Noble. Just a quick question on the topic that you're commenting on. Did Commerce City as a municipality approve this location, these locations, I guess?
No, sir. This is a drilling and spacing unit, so it's not at that point.
Okay, so it has not been formally approved by Commerce City.
No, it has not. No sites in Commerce City have been approved.
Okay,
By Commerce City itself.
It sounds
Thank
like no applications have been filed. Is that right, Councilmember Noble?
Could you please say that again?
I said it sounds like they haven't applied for Commerce City approval.
Yes, they have applied for Commerce City approval. What occurred, if I can for just a second, Extraction Oil and Gas had submitted applications for drilling and spacing units in 2018, and those drilling and spacing units were approved without people being aware, mostly because developers in this area own the mineral rights. Some of this is information that we civilians learn by educating ourselves very rapidly. But in 2019 or late 2018, Extraction Oil and Gas sent out letters to mineral rights owners in this area and notified them that they were withdrawing the approved drilling and spacing units of 2018 and instead were replacing them with new drilling and spacing unit applications. Those new drilling and spacing unit applications were protested formally under COGCC rules and brought before a public hearing officer. At that time, the public hearing officer bifurcated some of the many drilling and spacing unit. It was one massive drilling and spacing unit that covered 20 some miles, thousands of homes. The hearing officer bifurcated each down to their own drilling and spacing unit numbers. In this particular case, Pelican, the site, which is DSU 8 on your consent calendar, is also Reunion. But at that time, there were no known residents to protest as individuals. The hearing officer did not believe that although it was considered one neighborhood, which is Reunion, the only thing that separates it is a street running between 104th, and separated this drilling and spacing unit off, along with the drilling and spacing unit that would hydrofrack under Bar Lake. These two, DSU 6, Bar Lake, DSU 8, Pelican, Reunion South, are on your consent calendar today for your approval. Your consent calendar means that generally unless you pull an item, which you can do, you would approve the consent calendar as a whole based upon the recommendations of staff. I wanted to draw your attention, though, to the fact that this is part of an effort that residents undertook in this area over the course of the past year. For those of you who are new to the commission, you wouldn't be aware of that. And that's why I'm here today, is to share that information. I'm sorry if I gave too long an explanation, but
Thank you, Ms. Noble. Okay, thank you, Ms. Commissioner McGowan.
Thank you, Mr. Chair. This is one I had questions about anyway, so perhaps when we get to the consent agenda, we can have a conversation about it.
Agreed. I think it's better to have that conversation when we get to the consent agenda. Okay, we now have undertaken public comment. Ms. Amaro, if you would put Ms. Noble back into the other spot as opposed to being on the panel, that would be great. And we appreciate Ms. Noble bringing that to our attention. Looking at our hearing agenda, I believe that now we have on the agenda commissioner discussion, best practices for communication with the public and parties regarding applications. Mr. Davenport, I believe maybe this was segueing off of the work that we did earlier. Is that right?
Thank you, Mr. Chair. Yes, that's correct. Certainly not a requirement for the commission to have this discussion. My thought was the commission could have a discussion about how it wants to deal with some of the communications that we discussed in the course of my presentation. For example, the emails that Commissioner Messner mentioned about a pending application. There are some other issues that I'm happy to raise with the commission in regard to how they want to deal with those communications, but that was the purpose of the discussion.
Okay. Unless commissioners have thoughts in terms of moving through it, do you want to just sort of throw out the couple of issues you may have and then we can have a quick discussion?
Sure, I'm happy to, thank you. Commissioners, as I see it, there are a couple of kind of buckets of things for discussion. One of them is communications with the director and staff regarding enforcement matters, and specifically if you are comfortable with the ex parte rule and stopping communication with the director at the time a hearing application is filed. The next bucket is how to deal with the communications that really Commissioner Messner raised. Individual emails, things like that about a pending application, OGDP, CAP, anything like that. And if you want to, the third one is to have a discussion about the open meetings law and noticing what I would call non-full commission meetings, but other meetings that may need to be noticed that the commissioners will attend or participate in. Again, not a requirement that you have this discussion right now. They were just the items that were on my list.
Okay. Well, looking at my other commissioners, do we feel we need to, do we need to talk through these sorts of things? Do we feel comfortable with the direction we've already received, et cetera? Commissioner Messner?
Thank you, Mr. Chair. So I think I'm struggling to understand, and I do think there needs to be discussion around, how to formalize interactions between us as commissioners and local governments in particular, because I think there's a couple different things going on. I mean, one, if we go and participate in a local government process as an individual commissioner, even any information that we get from that local government process, we can't really utilize. My understanding is that we can't really utilize that information gleaned from that process in any kind of decision making in our process. Inevitably, if we're going to participate as individual commissioners, as we've indicated we may, one of the questions that we're going to get asked is, either in their process or on the phone outside of their process is, if we approve this location, is it going to pass muster with the COGCC? And I know that that's not a question that we can answer, which is why it seems like if local governments are interested in doing a concurrent permitting process, that we're going to have to come up with some sort of formalized mechanism to do a joint hearing, so that whatever information that is received, whether we're in this joint process, can be utilized in both the local government process as well as in our process, and is on the record, and we can use it as part of decision making. Otherwise, I'm not sure how this concurrent process with our input would work. Now, on a staff level, I think it's a different thing, but I mean, if we're going to be involved as commissioners, I mean, to me, this is a big sticking point.
But I think, I mean, and I've been giving some thought to this as well, Commissioner Messner, and I've even had some discussions with Weld County, for example, on this, and we're at the very nascent stages of sort of working through these issues. But I think there are some workarounds that could work for, and I'm just creating a hypothetical for discussion purposes. But if local government X wants to have a concurrent permitting process where the operator files both with us and with them, one method that would allow both governments to receive information about the permit would be to have a concurrent study session or work session or information session in which the application is presented to, and in particular under Zoom circumstances, we can really easily do this as opposed to all getting in a big room together and trying to hear that information. And I think that we could hear that application, quote, hear it in quotes, from the applicant in a manner in which both the local government and we have noticed it as a hearing, and we are both there, and we both, take attendance, and then we hear it, and we're even able to ask questions, etc. I think that's something that we need to work through ourselves and also with our staff, because I know that in discussions that I've had with Director Murphy, we've already, had the OGLAs reach out to some communities to talk about concurrent permitting. So I guess I appreciate the point, and I think we do need to figure it out. I think that that's something that the staff is still working on. That I know we've had some discussions about how we're reaching out to local governments, et cetera, and I'm circling now, and Julie's just arrived and is showing up, and maybe she can help provide some additional perspective from a director and a staff perspective on this question.
Yeah, I think it's going to be important to engage on, a couple of different levels. One is how does work process flow? And that's probably more of a staff level conversation. And we're engaging in those conversations with Weld County and Garfield County in particular. And then the other is that higher level conversation. And we're all going to have to learn together about how to do this. And I don't know if there's a way to create a joint calendar to help be aware of who's doing what and when, to help, kind of answer some of the process level, the who and when questions. But I don't have just tons of insight either. Part of it is going to be how you all want to engage, and it's probably easiest to divvy it up by jurisdiction to keep those lines even or easy. And then, staff will be available to support, and we'll be working day in, day out with any number of the jurisdictions who are working on oil and gas issues within their boundaries.
Well, Director Murphy, I think we also need to, and I'm sure you're doing this, but we're all doing a gazillion things right now as we get ready to turn the permitting regime on. But, there does need to be outreach to, create a list of those local governments that want to do concurrent permitting. And if so, then how do we reach out and establish that in an effective manner versus which one of those want to have initial permitting versus those that don't necessarily care. And there's probably some other buckets. So A.G. Davenport, you unmuted. Did you want to weigh in on this as well?
Thank you, Mr. Chair. I had just started to think that maybe I didn't do a great job of directing the discussion that I was sort of anticipating or contemplating. I think that Commissioner Messner's question is obviously a great one. It's one that is probably going to require much more discussion. In my view, the communications with local governments, especially in the concurrent permitting process, is sort of a very special but critical subset of all of these communications that we were talking about. What I was contemplating was really on January 15th, we're going to start getting OGDP and CAP applications or shortly thereafter. And if the commission receives, for example, in the hypothetical that Commissioner Messner raised, an email from a member of the public, what does it do with that email about a pending application? Or if the commission receives an email from someone about an NOAV that was just issued, what does it do with that email? Those two kind of buckets of communications, I think, would be maybe beneficial for the commission and the public as a whole to know how to deal with those types of emails or phone calls or text messages, whatever they may be. And that's kind of what I was contemplating about this discussion, so that there was at least some consensus on how to manage those types of communications before they may actually start occurring.
Help me if I'm oversimplifying this, but I mean, again, I do go back to when I was a county attorney. When those sorts of things happened, I just told the commissioner to forward it over to the planning department or forward it over to the NOAV official and call it good. I mean, then it becomes part of the record. And then when the rest of the when the commission as a whole takes it up, whether it's an entitlement matter to a permit or whether it's an NOAV, everyone's going to have the ability to take a look at that email.
I think that's a great way to handle it, Mr. Chair. My thought was, since we don't have a process in place for that right now, a discussion of that process, and so the commissioners all understand and are on the same page with that, might be a good thing to have. And we can have it now, we can have it later, or we can see how it works out and deal with it when it actually happens. But in what you just talked about, one of the additional issues is, and this is I think a matter of policy for the commission, this commission in OGDP has a public comment process to the director that's provided by rule. Just an email to a commissioner is not what that rule contemplates, in my view. And so what happens with that email is, I think, part of this discussion.
Well, the other, Commissioner Messner.
I mean, the way that I've been told to deal with this in the past, and it may be applicable here, is similar to what Commissioner Robbins or Chairman Robbins is indicating, but understanding that, you know, there is that process to provide public comment and a formal hearing process and timelines associated with that. And so it does get sticky. So, you know, what's been done for me in the past as a county commissioner was I had boilerplate language. So if I got one of those emails, I could respond to it with boilerplate language that said, this is the way that you provide public comment on applications. These are the portals. These are the links. We appreciate, you know, your interest in the topic. And that was something that I was able to send out as a commissioner. That's it. That was the only communication. It was just boilerplate, but it still gave the interested party the necessary information to be able to engage in whatever the topic was. And I found that to be helpful. I also had that same boilerplate memorized for phone calls. So, I mean, I don't know if that's something that we could apply here or not.
It works for me, John, and or Commissioner Messner. And then did you just then delete the offending email and it was just taken care of that way? And then the constituent had in their hands the appropriate method for providing input under your land use code. right?
That's correct. Yeah.
I'm good with that if other commissioners think that's a good approach, and then we don't have to worry about the offending email coming in at a time outside of the formal public comment, but the constituent is given the opportunity to know how to do it right. And if we all think that makes sense, we can ask E.g. Davenport to draft up that language and get it to us, and we can keep it in our back pocket and send it out.
Mr. Chair.
E.g. Davenport, are you comfortable with that approach?
Yes, thank you. I'm happy to do that. If with the commission's permission, I can draft up also sort of a document or a PDF even that the commissioners could send out to just attach to an email and send to that person that explains how our rules provide that the public may participate in the process.
And do the same thing for pending NOAVs.
Okay. I will draft that document and send it to you for your comment.
Okay, great. And again, just for all of our stakeholders, there's 56 or some odd folks on the line. What we're talking today is this movement from commissioner. For the first 6 months, we've only been commissioners, and as quasi-legislative commissioners, we can talk to you about our pending rules. That's not problematic, but we're engaging and we're learning and we're creating guidelines around the next. So from here on out, we're going to have 2 different hats, the quasi-legislative, but we're also going to do daily permitting and caps and et cetera. And so this has been a good discussion. I appreciate Messner's thoughts on some of these more particular finite sort of things. So that would sort of put a cap on that part of the discussion. Director Murphy heard us in terms of some of the thoughts that you and I in particular, because we're kind of that, and perhaps we can set up a time where we can understand further some of the piece and how we might create some opportunities for.
Is Mr. Chair coming out for in and out for anybody?
E.g. Davenport.
Yeah.
Mr. Chair, you're coming in and out.
I know. I apologize. I'm working from a home that has 3 home workers, and so I think we're overflooding the system. So bear with me. But go ahead, whomever wants to go next, because I didn't see any hands raised.
Mr. Chair,
Yes.
I heard my name. Did you ask me a question?
I was just going to say, what's next?
Oh,
But if Commissioner McGowan has something, please. Okay.
well, I think, so I believe we're kind of through this discussion piece on the agenda. I was going to mention one more thing. In regard to ex parte communications, there may be an opportunity to use the e-filing system to help with sort of auto responses or something, or managing that kind of thing. With the commission's permission, I'll reach out to the hearing staff and see if there's a more efficient way that I might not necessarily have thought of to manage some of those things in the hearing context as well. And then if that is the end of that discussion, the next item on your agenda, Commission, is the consent agenda.
Any others with thoughts, or are we ready to move to consent? Okay, assuming I'm not freezing up, I'm not seeing any others with thoughts. So we're going to move to consent. And I would recognize Commissioner McGowan, who expressed some interest in having a discussion around the at least the extraction matters that are on consent.
Thank you, Mr. Chair. I actually had questions about Group A, Group C, and Group D, and then I had some questions about the plug nickel enforcement action. So I don't know what the pleasure is of the group to tackle first.
Mr. Chair. Commissioner McGowan, if it's acceptable, this is Assistant Attorney General Davenport. If it's acceptable to you, I'd just suggest we take them in the order you just stated them. Starting with the consent agenda and then moving to the recommended orders for enforcement and any other recommended order that is on the enforcement side. And I'd also suggest that if we have the hearing officers for those matters, it may be appropriate for them to show up. I see we have a couple of hearing officers, I think, who are already panelists. So if they're available, it may be helpful. They may be able to answer some of your questions.
Okay, so I'll dive in, and then if other folks want to jump in, also feel free. So when I read the Group A request from extraction for their drilling space, their spacing unit, right? Their DSU. I was wondering why they had started off with 8 and then it had been bifurcated and only 2 had been moved forward. And I was curious to know if originally these were submitted as a whole grouping for efficiency, and whether or not, I'm not sure I'm explaining myself properly, but if we just take 2 and just do 2 instead of the original 8 that were requested, are we being less efficient? Were these all part of one geographic space or area together, or not? So that was one of my questions. And because I don't know what the 6 that were left off and were eliminated were, it was unclear to me if these are all like part of one request to try to be efficient about pulling the minerals or not. And then I did have a question when I read the consent agenda for this one. It did seem to me that Commerce City had signed off on this, and now it seems unclear to me based on the public comment that we heard earlier, and so I wonder if that could be clarified. And then I just wanted to also be clear or get confirmation that getting approval for a spacing unit does not mean that you can start to drill. We still have to approve an actual permit to drill, correct? And so those are the questions that I had.
Chair, if I may start.
Yeah, and just for everybody's perspective, I'm now on my iPhone trying to run a meeting, which is really difficult because I can only see one of you at a time. So I would encourage everyone just to speak up, and then let's try to see if we can get through this, and I apologize.
Thank you, Chair. And Commissioner McGowan, I'm going to try to take those questions a little bit in reverse order. First, approval of a spacing unit does not allow drilling. You also need a permit. So that's the easiest question. The other questions about Commerce City's status and the overall plans for extraction and what they're thinking in their proposal don't often actually filter in through the filings related to a spacing unit. So it may be more appropriate to have extraction come answer your questions on behalf of themselves. That being said, Hearing Officer Thomas may have better insights than I do, and would happily ask him to share whatever he can. And if not, we'd be happy to get extraction here to answer your questions if that's the right path.
Hearing Officer Thomas.
Thank you, Commissioners. Commissioner McGowan, I can answer the procedural questions that you initially raised. These 8 DSUs were originally filed in one application. And as noted in the order to bifurcate these, which took place a bit later after a pre-hearing conference on that matter, Hearing Officer Rouse, who was assigned to this case at that time, bifurcated the 2 for which there were no protesters within those units. The remaining 6 units were each bifurcated into a separate docket and separated based on the protesters in that particular DSU's area, so to speak. So the result was quite a large number of dockets split off from that. Now the status of all of those is different. Excuse me one moment, I'm looking and it looks like it was actually split into 6 separate dockets. And the one before you today, docket 230, that pertains to the 2 for which there were no protesters. Hearing Officer Rouse actually in his order discussed that this would expedite and be more efficient in order to split up the protesters based on which DSU affected them, as well as push forward the ones for which there were no protesters. And that's what we have here. To briefly touch on your second question, yeah, the 511 testimony does contain an agreement with Commerce City. They provided that, Extraction provided that in their testimony with regarding to the citing requirement. I don't want to speak too in depth on that. I think that Extraction is better positioned to speak on that matter. And I believe Counsel for Extraction is in the chat if you would like to bring him in and ask additional questions regarding that matter.
Commissioner McGowan.
Thank you, Mr. Chair. So I guess I have some questions that I'm wondering if the other commissioners would be interested in learning a little bit more. But I guess I also see that there's a difference between politically splitting off 2 units that don't have any protesters. That's a kind of a, I'm trying to think of the right way to word this. I'm not sure that there's a difference to me doing that for expediency because there's no protest to those specific units versus were all these units meant to move forward together because there was a more efficient way to pull the minerals. And so I may be putting the cart before the horse, but if we were to approve these 2 spacing units and then we were to approve permits that went along with them later on, applications, then is Extraction going to come back with the other 6 that are related to these 2? And then that doesn't seem very efficient to me if it's related to these 2 or if they're just separate altogether and they wouldn't be sharing pads, they wouldn't be sharing space. Does that question make sense?
It does, Commissioner McGowan, but I do think that Counsel for Extraction and anyone else for Extraction would be better positioned to answer that particular question at this time.
Commissioner Messner.
Thank you, Mr. Chair. I would like to agree with Commissioner McGowan that I would like to get counsel from Extraction and hear their testimony both about their 511 statement regarding approval by Commerce City, as well as some of the other questions that Commissioner McGowan has, and get a little more information on this particular docket number.
Hearings Officer Thomas, a question for you from a procedural matter, and maybe this is to A.H. Davenport. In order to, so we've got 2 of us that want to do that. I tend to agree, so that's 3, and I bet the others do too, except for I can't see them all on my iPhone. But is the appropriate procedure to pull it off consent and then have a hearing or have a presentation today, or is it appropriate procedure to just put this on a docket next week in which sort of everyone is aware that we're going to have more of a hearing on it as opposed to consent? I'm looking for some direction from my AAGs and or hearing officer.
Mr. Chair and
yeah,
Mr. Thomas. All right, I'll start out on this and you're welcome to add if you'd like. The commission does have a rule on consent agenda. It's Rule 531 under the current rules. It provides that any commissioner may remove a matter from the consent agenda prior to voting thereon. So to be clear about that, that does not require a commission vote. A commissioner can remove a matter from the consent agenda. It also provides that a commissioner may request clarification from the director, or the attorney for the applicant, or the hearing officer. So in the past, what the Volunteer Commission has done is if you have some clarifying questions that you'd like to ask of the applicant or the director or a hearing officer, you can do that. You don't have to necessarily pull it from the consent agenda to do that. If we start getting into, and there's a gray area here about how sort of, are these just clarifying questions or are we really starting to get into the meat of the application itself? if you want to pull it from the consent agenda, if we need to have an actual, if it starts to feel more like a hearing, and you want to pull it from the consent agenda, the rule also provides that if it's pulled from the consent agenda, it can be heard at the end of our remaining agenda or at a next scheduled meeting. But it can only be heard at the end of our current remaining agenda today if the applicant agrees to that. So the applicant essentially may not be prepared to have what feels like a full hearing on this application today. And if they aren't prepared, if they would like to have some people here who are witnesses or know more about the technical details, the rule provides them that opportunity to do that. What if I can suggest something? It feels to me like we're still maybe in the realm of a clarifying question. You want to understand what happened procedurally on this. And if you want to, you can bring extractions counsel in to answer those procedural questions and kind of what happened before. If we start getting into more of, at least in my view, what Commissioners McGowan's issue of this doesn't feel efficient, and we start raising what I think are greater issues of, was the hearing officer's decision correct? Then I think that's a meatier issue that we should set this for a, pull it off consent and set it for a hearing at the end of this agenda or later. But I'm happy to hear opposing views from the hearing officer or the director if they have them.
Thank you, A.G. Davenport. I'm scrolling through my iPhone screens to see if I can find Commissioner McGowan or Commissioner Messner. I'm looking to you. Do you want to just take him up on that and bring in the counsel for extraction and get their perspective and sort of wait around the issues here and then see if we're getting more full on into a hearing mode or if we're just getting clarifying mode?
Mr. Chair, I'm okay just hearing from the counsel for extraction as to whether or not they are prepared to answer any clarifying questions regarding this. And my particular clarifying question is around the statement made, during the hearing that they had approval from Commerce City for these two locations for drilling and spacing units. If they're not prepared to answer that at the end of today's agenda, then I'm happy to hear it at the next meeting. So timing is not an issue for me, but I don't know as I'm ready to go to a full hearing unless others have more specific questions or want to hear more information.
Okay, thank you, Commissioner Messner. I'm trying to look at other commissioners. Why don't you speak up if you want to add anything to it? Commissioner Njapa.
Thank you, Mr. Chair. Yeah, I mean, I concur with what Commissioner Messner just suggested and just trying to see if the Counsel for Extraction is prepared to answer some questions. I also had some similar questions, more kind of relating to the nature of the prior DSUs that were vacated and what I noticed to be kind of a trend of larger sized acreages as we were, as they were kind of being updated, but also given, what we heard in the public comment, just a little bit, perhaps trying to understand a little bit more about the nature of the protests. Though I do understand that we're not talking about DSUs that are currently being protested with these two being split off. So with that said, I think if there is agreement from other commissioners as well about just having Counsel for Extraction, let us know if they're prepared to answer those questions. That would be great.
Chair, if I may,
Okay.
Elias, can you bring Counsel for Extraction in?
Certainly.
Thanks. Or Hearing Officer Thomas. That's what I meant to say, of course.
Okay, I've brought Mr. Storm, Counsel for Extraction in this matter in. So Mr. Storm, you can unmute and if you're available to address any questions.
So, Mr. Storm, assuming
Is
you're
there a way that
here.
we could see him also?
I see Mr. Storm's unmuted. I'm not sure if he's on camera or available for that, but I'll leave that
Let's
to him.
start by Mr. Storm, if he can acknowledge. Are you here? Can you hear us? Can you talk?
Mr. Chair, I did see a chat from Mr. Storm, though it wasn't, it looks like he may have started typing and then entered. I think he's here in some capacity, but we haven't heard from him yet.
What does his chat say, A.G. Davenport? I've encountered.
It says, I've encountered some irregularities with Zoom. I'm attempting to log in and be heard.
Why don't we do this to my fellow commissioners? Why don't we pull Group A from the consent agenda, and we can then see if there are questions on any of the other matters on consent, and then perhaps move through consent and get it approved without Group A. And then if Mr. Storm is able to join us, we can ask him questions. And if not, we can just put extraction on next week's agenda. I think one of the things that, as A.G. Davenport spoke about, there was a hesitancy with previous commission because they only met every 6 weeks or so. From our perspective, we're meeting weekly, and so the delay is not nearly as trying for the applicants. So with that, are there any other questions with regard to the other Group B through Group J, I think it is, on consent? Commissioner McGowan?
Thank you, Mr. Chair. So I had a question for Group C. It's Great Westerns. It's a pooling request. It's 2009-00246. And this is just for my own, perhaps morbid curiosity. There seemed to be a large number of unleased owners that elected not to participate. And I was wondering if is it under a subdivision or everyone's a mineral owner, or I just had never seen that many names on a request yet. And so I was just curious to know why that was. So I don't have any concerns. I just was curious.
Who can take that question?
Apologies, Commissioner McGowan, this is docket number 246.
Yes, I think so.
Okay, one moment, please. I can't really speak to the detail of, why there's that many, but it would just be situational based on where this is. Sometimes we get a lot of names, sometimes we get barely any. So I don't have any specific detail as to why there's so many in this particular docket, but this isn't something that's extremely unusual, I would say.
Okay, thank you. And then, Mr. Chair, for
Please.
For Group D, for Noble, all of their applications said that they were not seeking recovery of costs, and I was wondering if that was unusual and if that meant that they owned everything and so they didn't need to seek recovery costs from anybody. Again, I don't have concerns, just curiosity for me.
Mr. Thomas?
Briefly, that just depends on the situation as well. I'm sorry, commissioners, for using that repeatedly. In some situations, it is because the operator owns the entirety of the area to be pooled. In some cases, it's simply a decision they've made not to seek penalties against certain non-consenting interests. And with that, to avoid any of the issues that may come along with that. I think that's more of a business decision that the operator may decide on their own when they don't own all of the tract.
Commissioner McGowan, follow up?
That's all I had. I know that we're gonna do some kind, I think we're going to do a docket around pooling and spacing. And so I think Commissioner Gonzalez is going to lead us in some of that, but I guess that would be something I'd be interested in discussing as part of learning about pooling.
Yeah, I agree, and so I appreciate you raising that. I have just a tactical question or a procedural question for A.G. Davenport, and this is not to disallow us from doing this on the record at the hearing, but are these sorts of questions, which I think are good questions, is kind of clarifying questions. Could a commissioner ask hearings officer Thomas this ahead of time or offline, and that would give him an opportunity to kind of investigate a little bit? And this gets back to kind of our ex parte or our open meeting sort of questions, but I think that's allowable, but I would like some direction on that either now or later.
Thank you, Mr. Chair. In general, my preference would be just to avoid any issues that if commissioners have questions, something on their docket, whether it's a consent agenda matter or enforcement matter, that you send those questions to me, and I'll see if I can answer them. And depending on what the question is, then it may, in some circumstances, be appropriate to be able to talk to the hearing officer as well. The hearing officer may be able to answer it, for example, by just directing to one of the pleadings in the portfolio, in which case that's public knowledge. Hopefully that's sufficient, but in general, if a commissioner would like to ask questions in advance about a matter on the consent agenda or an enforcement matter, please ask me and we'll deal with it from there.
Okay, that works too. I just was thinking that there should be some method ahead of this, because it gives the staff the opportunity to not get caught sort of flat-footed, and it also generates clarifying information which helps us with good decision making. Any other thoughts, questions, concerns on consent from anybody? Commissioner Messmer?
I'll move approval of the consent agenda items B through J as presented.
Do we have a second?
Second.
We have a motion and a second. Is there further discussion? Seeing none, all those signify if you're in approval by saying aye.
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 Any opposed? Seeing none, motion carries. Consent, with the exception of Group A, is approved. At this point, can someone help me, because I'm still incapacitated on my iPhone? Is Mr. Storm with us? Commissioner Messner?
Oh, sorry, I don't know about Mr. Storm, so I can wait on this one. I do think that we have a couple of commissioners that are interested in discussing an enforcement issue that wasn't part of that motion.
Mr. Chair.
Yeah, speak up.
Apologies. This is A.G. Davenport. I think Mr. Thomas has already let Mr. Storm know that the matter's been pulled from the consent agenda and we'll return to it at the end of our agenda. So in my view, it would be appropriate procedurally for the commissioners to discuss their questions on the recommended orders for enforcement. And we do have an agenda item of commissioner discussion to then I think once we get through the enforcement stuff, it's up to the commissioners if they want to return to Mr. Storm or have their comments first and then Mr. Storm.
Go ahead, Commissioner Messner. I believe you, or at least one person that had enforcement questions.
Chair, if I may we bring in Enforcement Officer Rosenberg if we're going to be talking about plug nickel?
Yes, please.
Mr. Chair.
Yes.
So I can go ahead and ask my question, and then I think there was a couple other questions from other commissioners, but you know, on this particular enforcement where we had the penalty, part of the penalty was suspended, part of it was forgiven. I know that so the operator is paying the $500, and then $4,500 is forgiven, and then $5,000 is suspended until completion of the audit and clean audit for a year, if I remember correctly. My question was, in situations because of financial considerations where we are suspending and or forgiving portions of the fine, whether there was a public project that was considered as part of this in lieu of having to pay the fine, a public project being of public benefit, I think, as part of Rule 523. So just thoughts on that and whether that was considered as part of this in a situation where we are forgiving $5,000 or $4,500.
Would you like me to respond, Commissioner Resner?
Yes, please.
Okay, thank you. This is Enforcement Officer Rosenberg. Nice to meet you. I've not actually met any of you, met you in person yet, but in this instance, we did not consider a public project in lieu of forgiving a portion of the fine. Staff felt in this particular instance that a self-audit would achieve ultimately the same result, which is just to ensure compliance and to ensure that there isn't going to be any more venting without approval. So in this particular instance, we did not consider a public project.
Thank you, Ms. Rosenberg. I appreciate that. I'll just make my thoughts is that I think the idea of the public project is a good one, and particularly in a situation where we're not able to where an operator doesn't have the financial means in order to be able to meet those. And I do understand that the audit is a beneficial thing. At the same time, I think that there's probably some creative opportunities out there to do some public good in lieu of having to pay, or in lieu of us, both suspending and forgiving, what ended up being a, somewhat significant fine. So those are just my thoughts. Moving forward, that I think that the idea of the public project, understanding that there's two different elements here, right? So there's potential like no cost education type of public projects that do public good. And then there's the more financially significant ones that oftentimes happen, which are plugging and abandoning or plugging abandoned wells and so on and so forth. But anyway, I just wanted to put my thoughts out there.
Thank you.
Other commissioners? Commissioner McGowan.
Thank you, Mr. Chair. So I guess my thought process went down a different path, which was I completely understand looking at someone's ability to pay. I guess what was very concerning to me is that this operator, when we looked at their ability to pay, couldn't pay a $10,000 fine, which was reduced to $5,000 and then $500. And so I guess I had more concerns in general about what was going on with this operator. And I have some questions that I'm guessing you're not going to be able to respond to today, but I was curious about past violations and whether there was a summary maybe for this company, say for the past 3 to 5 years, and the amounts related to those violations and whether or not they were able to pay in the past. I'm curious to know how many wells this company has in Colorado and if they're operating or if any are being abandoned. And if we know if they're up to date on their financial assurance and their insurance, if they have an inability to pay a $5,000 fine, are we worried about the financial viability of this company? And maybe I'm misunderstanding what's going on with this company, but those were thoughts that came up when I read about this violation.
Well, and I can go ahead and answer your questions for you if you like. Would you like me just to go through them? So this company has actually only received one warning letter in the first quarter of 2015. That's the only disciplinary action they've had against them since then. And this particular, with regard to their recent inspections, and I'm looking at a document too as I'm talking with you, so forgive me. 2 of their wells were inspected in November with no problems. The well at issue passed its last inspection in August, and there were no corrective actions associated with that either. So they have a pretty good history of compliance. They are a smaller company. They have 11 wells total in Colorado. They're all stripper wells, which are low producing wells, and they're all quite old. The well at issue, for instance, was drilled in 1961. Let me see, I'm just looking through some other documents. Their financial assurance, I did check on that. They are up to date on that. With regard to their insurance, it's, I believe it's Rule 708 does require operators to maintain, or current Rule 708, to maintain, I think it's $1 million in insurance. That is more for traditional insurance related matters. And the COGCC is required to be a certificate holder for insurance policies. So we would get notification, presumably, if their insurance were canceled. So we don't have any reason to think their insurance has been canceled. And they do have cash bonds, both at the state level and the federal, because a lot of their wells are on BLM minerals or land. And with regard to the financial viability of this company, staff is not concerned about their financial viability. I don't know if you're aware, we have an enforcement policy that we follow that the commission created in 2014, 2015. And that does set out sort of a procedure for when an operator claims inability to pay. And what we do is we take their, what the violation was, what staff thinks, the compliance history of the operator, and then we do take a look at their financials. Our policy is to delete all of that information when we get it, just because of after we review it rather, because of the sensitive nature of everything associated with it, and we don't want to get caught in a CORA issue having somebody's tax records and things like that. But we are not concerned about their ability to operate. In this instance, they felt, and they could have paid this, it just would have been a harder burden on them than staff felt was necessary relative to the, considering all of the circumstances. And so I don't know, does that answer all of your questions?
That was really very helpful. I appreciate you responding.
Yeah, you're welcome.
Thanks. It gives me, I guess, some comfort. Thank you.
Other questions from commissioners? I'm scrolling through you. I'm not seeing other questions. E.g. Davenport, at this point, since we've exhausted questions about the hearing officer recommendations, we don't need to do anything at this point, right?
Mr. Chair, that's correct. I do want to double check. I'm not sure if we have, there was another recommended order. I wasn't sure if the commissioner had a question on the other recommended order or not. Okay, I'm seeing shaking heads. So shaking no heads. Yes, that is correct. Under our procedure, under our rules for recommended orders, if the commission is comfortable with those AOCs becoming final orders of the commission, then the appropriate action is no action.
Okay. Going once, twice, and 3 times for no action with commissioners. Scrolling through you. Okay. That gets us to the last agenda item, I think, which is commissioner comments. Go around the room. Comments from any commissioners for the general good?
Mr. Chair?
Commissioner Messner?
I was just going to tell you, Commissioner Hackett had his hand up.
Oh, Commissioner Hackett, go ahead.
Thank you, Mr. Chair. And this will be quick. I actually had a question and then just a repeat of a comment from the December 15th hearing. Question about the e-filing system. I know staff has already provided training to the public and operators. I missed those trainings, wasn't able to make those. I was under the impression there might be an additional training maybe in January or February for commissioners. I'm wondering if maybe I missed that, or if I should consider setting up a separate meeting with staff to get trained up on the new e-filing system.
If I may, Chair.
Director Murphy?
Thanks. Yeah, thanks for the question, Commissioner Hackett. And the trainings that we're doing with the operators on new forms are occurring bi-weekly, and we're recording those to make them available to the public. So I think you can jump on the website and get those. And also, we're happy to help work with you or the rest of CDPHE team to understand those components. And sorry, I have a huge delay on my video.
Thank you for that, Director Murphy. And the only other comment I wanted to provide was just a reminder for commissioners and then members of the public who maybe didn't attend the December 15th hearing. CDPHE is partnering with the Colorado Bar Association to provide a free continuing legal education tomorrow from noon to 1:30 that I think some folks might be interested in. It's called Giving Voice to Disproportionately Impacted Communities in front of the Air Quality Control Commission. And in addition to providing education about what the Air Commission rulemaking process looks like and how to effectively navigate and participate in that process, it will be encouraging pro bono attorneys to consider taking on clients for free legal representation in front of the Air Commission for the upcoming greenhouse gas emission reduction rulemakings. So if folks are interested, I'll just go ahead, if it's appropriate, and repost that in the chat, and people can attend as they're available. But thank you, that's all I had.
I think we lost Chairman Robbins again.
Commissioners, if it's acceptable to you, I would just, to keep things moving, see if we had any other comments from the commissioners. And then we do have one more agenda item after commissioner comments. All right, it doesn't look like there are any other comments. Mr. Chair. Maybe.
Hi guys, I just got.
Oh, okay. Mr. Chair, I was just checking to see if we had any other commissioner comments. We do not. And so I think our last agenda item then is to bring Extractions Council, Mr. Storm, back in to answer those questions for our consent agenda Group A item.
Thank you, and I apologize for my lack of ability to participate here.
Also, Mr. Chair, just so you know, we're looking at your computer screen and we can't see you.
I give up.
Hearings Officer Thomas, if it's all right, Mr. Chair and Commissioners, I'll see if Mr. Hearings Officer Thomas can bring Mr. Storm back in.
Certainly.
Yes, please do.
Thank you.
Okay, Mr. Storm, you've been promoted to the panelists, so there you are. Great.
Thank you, Commissioners. I think I can be seen and heard now. Can we just confirm that that's the case? First, I apologize for the technical difficulties, not expecting to be called on. You can't test before you get into the portal, and so a little bit unexpected, just a difficulty caused by our remote desktop. This matter was 1903-00230. It was a spacing application, and Commissioner McGowan noted that it covered 8 drilling and spacing units. That was really an effort by Extraction to create some procedural efficiencies. Obviously, the rules have changed significantly, but at that time, it was rather common, not only in this area, but other areas of the field, to combine several drilling and spacing unit applications onto the face of one application. And That was the purpose of placing 8 kind of geologically relevant DSUs on one application. It was filed in January of 2019, and several protests came in March of 2019. So to siphon off the issues and make sure kind of the relevant protestants were affected in the respective drilling and spacing units, we filed that motion to bifurcate that matter. The purpose, again, of that bifurcation was simply to narrow the issues and make it very certain when one protestant was speaking or addressing some of the issues that they had raised, that they were raising those issues in relation to the drilling and spacing unit in which they owned. And there were 2 drilling and spacing units where there was a protest to the original application, but that protestant didn't own within those drilling and spacing units. And those are the subject of that kind of bifurcated application, that docket number 1903-00230. I think there were also some questions about the status of local siding with Commerce City. It was submitted in our Rule 511 testimony that there is an operator agreement that provides for preliminary approval of the locations that are subject to those drilling spacing units. Ms. Noble is correct that the actual permit locations, permit applications are pending before Commerce City. The operator agreement is a little bit layered, and it's probably not germane to the discussion to get into that, but there's an operator agreement with the preliminary locations, and then there's kind of a secondary wave of permit applications that takes place. And those 2 things are both, those are occurring and are being reviewed by Commerce City. There's some procedural question about whether it'd be more appropriate for this to be heard kind of on the Commission's next hearing. I think if there are some more pointed substantive questions about timing and status of those applications, the communications that Extractions had with Commerce City, it may be more appropriate simply to place this on the, I think, January 12th hearing or January 13th and have that discussion at that time. That allow Extraction to prepare some substantive materials and make sure that that they are prepared to answer all of the Commission's questions. But I did want to make an appearance and make the Commission aware of some of the more high-level questions that were raised during the public comment and subsequent discussion.
Thank you for that evidence or the clarification. Commissioner Messner.
Thank you, Mr. Chair, and thank you, Mr. Storm. And so my understanding, at least from what you're indicating, is that that Extraction has received preliminary approval for these drilling and spacing unit sites. I mean, I'm reading the docket in line, paragraph 25, section 25. It seems to indicate that Extraction has received approval. And so to me, that does seem conflicting a little bit because there is a significant difference between preliminary approval and actual approval. And so from my perspective and understanding that this is a drilling and spacing unit and not you know, a permit to drill or a permit for siting, I still would want some clarity from Commerce City because I do see some perhaps misinformation that maybe was provided to the hearing officer, and I don't know if that would have made a difference in the hearing officer's decision or not, but I would want to make sure that the record is clear.
Commissioner Messner, for my notes, could you please just restate the citation you just referred to? I stated line 25, but I wasn't sure what you were referring to there.
So I'll read it to you, but it says in 25, and this is the This is the draft report of the commission for docket number 190300230. And in section 25, it indicates regulatory testimony and exhibits submitted in support of the application by Nathan Bennett, regulatory supervisor for extraction, show that Commerce City is the local governmental agency with citing authority for the application lands, and that on September 19th, 2019, Extraction in Commerce City entered into an oil and gas regional operator agreement. The ROA stipulates Commerce City's approval of the location and provides that Commerce City does not protest or otherwise object to the location or application. The regulatory testimony further demonstrates that in developing the application lands, Extraction's operations will reasonably protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and will protect against adverse environmental impacts on any air, water, soil, or biologic resource. So that's the section. That's indicating approval. You're indicating preliminary approval. To me, those two different things.
Mr. Storm?
And I understand now. I wasn't certain whether you were referring to materials in Extraction's application or the report that was prepared by the hearing officer, but I would agree with you that those are two different things, and that some follow-up questions may be needed. I still think that they are of the nature of clarifying questions to the commission at this time, but I think it would be both beneficial to the commission and to Extraction. Extraction was afforded an opportunity to just have some company representatives here and a moment to prepare and make sure that everything within the hearing officer's draft report is accurate and consistent with the 511 that was submitted.
Hey, A.G. Davenport, should we continue Group A to the January 13th agenda at this point?
Yes, Mr. Chair, I think that's appropriate.
Okay. Do we have a motion to continue Group A extraction to the January 13th hearing agenda?
Mr. Chair, I am seeing some hands up from Commissioners Njapa and McGowan.
Oh, thanks. I again only have one of you at a time. Commissioner Njapa and then Commissioner McGowan.
Thank you, Mr. Chair. I just had a question in terms of procedurally how this would work. Are we able to hear from those who had submitted protests, or to be able to review the nature of the protests that were submitted? And is this going to be more of a sort of an item on the agenda where we'll have broader open discussion? That's my understanding in terms of pulling it off of the consent agenda and putting it this way. I just wanted to make sure I was understanding that correctly.
Mr. Chair, thank you. Commissioner Njapa, in regard to your question, kind of procedurally, yes, the purpose of continuing this for a hearing is to get into the merits of the application. However, in regard to hearing from the protestants, my understanding is there are no protestants to these particular applications. So there would be no one to hear from on the protestant side. There would be the applicant, Extraction. And if you had more clarifying questions for the hearing officer, my one caveat to that is I actually don't know the status of hearing officer Rouse currently, so I'm not sure if he's available. He would be available to answer any questions. That would be a question for hearing officer Thomas or Director Murphy.
I suppose we would want Thomas to get up to speed, since hearing officer Rouse is no longer an employee of COGCC.
Yes, hearing officer Rouse is no longer with us. This matter was reassigned to me in May of 2020.
And if it would be appropriate, I'll just make one comment. I think some of these issues are addressed in the written record, and I'm happy to submit that to hearing officer Thomas as soon as the Zoom call is concluded, so that he's aware. But hearing officer Rouse had determined that after bifurcation, no protests were pending pursuant to DSU 6 and 8.
Follow up, Commissioner Njapa.
Yeah, thank you, Mr. Storm, thank you, A.G. Davenport and Mr. Thomas. Apologies for my confusion there. I do understand that we were just talking about these two that are not being contested. Perhaps this is a separate issue that I can discuss with you, A.G. Davenport, but when the other matters come forward, I guess I'm just wanting to understand better the nature of the protest, or if that would be something that we would be able to review. Let me take that offline with you, and I can ask you some additional questions. Okay, so I think I am good in terms of understanding what is happening next with pulling this off of the consent agenda. So thank you.
Commissioner McGowan, did you have a question as well?
Thank you, Mr. Chair. Mr. Sturm, maybe you already addressed this and I just didn't understand when you were first talking about all of the DSU requests. Are those contiguous or are they different, separate geographic locations?
In not all cases are they contiguous. I'm not sure how you would classify similar geographically, but I can provide, there are maps in the Rule 511 testimony that show the respective drilling and spacing unit applications in relation to one another. In most cases, they are in closest a mile apart. The furthest ones are several miles from each other.
Thank you. So to your point, these units weren't necessarily submitted all at the same time because they were meant to all be drilled at the same time. It was done for convenience, and it was a past practice where you might have multiple DSUs submitted at the same time, but not necessarily contiguous and related to each other from a perspective of wanting to be more efficient about how you are putting your wells together and drilling. That they're not necessarily all related that way. I guess that's what I'm trying to ask.
Exactly. The application was filed for procedural and efficiencies in relation to notice and incorporating some of the relevant stakeholders that would be there, but the applications are not necessarily, or the drilling and spacing units, I'm sorry, are not necessarily at this time, connected through timing of operations, et cetera. Because of the rule change, the remaining drilling and spacing units may be addressed through some of the changing procedures at that time, but these are, in extractions estimation, eligible for approval on their own merit.
Okay, thank you.
Mr. Chair, I've got a question.
Yes, Commissioner Gonzalez.
Thank you, Mr. Chair. I've got a question, and this may be for A.G. Davenport, but we've talked about removing this from the consent agenda, and we've also talked about continuing it to the 113 hearing. And my question is there a difference between continuing a consent agenda item, meaning that it may land on the consent agenda for 113, versus pulling it off the consent agenda from today's hearing, and then it would be heard as a full hearing before the commission? I want to make sure that we're talking about the same thing here.
A.G. Davenport.
Thank you, Mr. Chair. The purpose of the consent agenda is for the commission, is really procedural efficiencies, for the commission to be able to approve a group of unprotested applications at the same time. I wouldn't necessarily characterize, at least as I understand it, what the commission is considering as a full hearing. There's still no protestants. I think the commission is still trying to get a better understanding of kind of procedurally and maybe some underlying factual background here as well. And that's including the status maybe of Commerce City's quote unquote approval or preliminary approval of locations. And so what I'm understanding that this is going to look like is extraction will be at this hearing next week. The hearing officer will be at the hearing next week to answer commissioner questions. So it doesn't constitute, in my view, a full commission hearing. It is simply a follow-up, a continued matter on the consent agenda where the commission has potentially some more in-depth questions than simply needs some clarifying procedural history or factual background.
Thank you, Mr. Davenport. That is helpful.
So are we at a spot where we are looking for a motion to continue this, A.G. Davenport?
Yes, I think that would be a good clarifying procedural step to have a motion to continue this to the January 13th commission hearing.
We have a motion.
So, Mr. Chair, I'll move. I'll move to continue docket number 190300230 to the January 13th, 2021 meeting hearing.
Do we have a second?
Second.
Discussion? Seeing none, all those in favor signify by saying aye.
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 Aye. Any opposed? Motion passes. Anything other from commissioners for today's meeting? Scrolling through and seeing none, I don't think. Do we have a motion to adjourn?
So moved.
Second.
A second. Great. Thank you, everybody. All those in favor to adjourn signify by saying aye.
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 Great. Thanks for the great meeting, guys. See you next week.